want to talk about what I think is a evolving and concerning change in our paradigm in this country about who we turn to for protection of our environmental rights. We've relied on federal protections for the environment for more than 50 years. The landmark federal laws protecting the environment, the Clean Air Act, the Clean Water Act, the Endangered Species Act, and others, were enacted in the 1970s at a time when there was bipartisan recognition in Congress that states and localities were failing to do enough to protect our air, water, and land, and that national standards were needed. Well, that bipartisan environmental consensus has long since eroded, and we cannot now rely on a bitterly divided Congress to act to defend our environment. Worse, a deeply conservative Supreme Court is undermining federal environmental protections, reducing the scope of basic laws like the Clean Water Act, undermining administrative enforcement, reversing long-standing deference to federal agency expertise, and imposing judge-made requirements for extraordinary clarity in statutory language that tie EPA's hands in confronting pressing environmental challenges. So in the face of a crippled Congress and a deeply conservative Supreme Court, it's becoming painfully clear that we can no longer rely on federal protections to fully protect our air and water. Environmental advocates need to work at state and local levels to fill gaps left in federal laws by conservative judicial decrees, and to ensure that citizens have the right to invoke protections under state law where they've lost federal protections. I want to describe one successful effort in Maryland to fill the gap created by a particularly damaging Supreme Court decision. In Sackett versus EPA, the Supreme Court in 2023 radically rewrote the longstanding understanding of the scope of the nation's waters, subject to the Federal Clean Water Act. EPA and the courts had for years grappled with the extent to which the act covered wetlands, but reversing decades of administrative interpretation that protected adjacent wetlands, the Supreme Court in May 2023 held that to qualify for protection, wetlands had to have a direct surface connection to another navigable body of water, making them indistinguishable from the surface water itself. The conservative justices also asserted that only rivers and streams with relatively permanent flows were themselves protected under the Clean Water Act, excluding intermittent and ephemeral streams, which make up more than half the nation's waters. So the Supreme Court's reinterpretation of the act in one blow deprived more than half of the nation's wetlands and arguably half of its rivers and streams of federal protection. Unless Congress acts, forlorn hope, I think, the only hope for protection for such wetlands and streams now lies with the states. Unfortunately, state protections for wetlands vary widely. Even states with strong laws have relied on the federal government to take the lead and lack the staff and budgets to enforce wetlands protections. Maryland is a good example. Maryland has strong state laws covering all its wetlands and waters in the state, but very limited resources to implement its program. And there's a critical gap where the Federal Clean Water Act allows citizen suits by organizations like the one I was working with, the Potomac Riverkeeper, to supplement federal and state agency enforcement capabilities. State law did not. Citizen suits are a critical tool to ensure protections of wetlands and streams where state or federal agencies either can't or won't take action to enforce the law. Working with a broad coalition of environmental groups, the Potomac Riverkeeper Network, where I worked, lobbied for state legislation to cure this gap. And in May of this year, we succeeded in winning enactment of the Clean Water Justice Act. The bill authorizes citizen suits under state law for violations of state standards, and it's targeted precisely at the gap created by the Sackett decision at the federal level. It protects wetlands that lack surface connection to other waters, and it also protects intermittent and ephemeral streams. And it authorizes the courts to award attorney's fees, a crucial right. Environmental advocates in other states are similarly working to ensure that their state laws fully protect wetlands and smaller streams to fill the hole Sackett left in federal law. And these efforts, I think, are examples of how we can turn to state legislatures and state environmental agencies to ensure continued protection of environmental values, even in the face of restrictions in the long-standing federal programs we've come to know and trust. We can't afford to rely solely on those federal programs. We have to reinvigorate the tradition of state-based environmental protections to fill the vacuum left by an ineffective Congress and a court that is deeply hostile to the environment.